Rita, did you write this matter in? I don't think you wrote this matter in.
Yeah.
The other one.
No, I don't even know what the other one is.
Okay. So I'll just do it. I'll just write it here. Mr. Knaller, what is the case number of this matter?
That will be 163 of 2015, my lord.
Can you just repeat?
SS 163 of 2015, my lord.
And what's its title?
I beg yours, my lord.
State versus?
Siboniso Mia. That's accused number 1, my lord. My lord, want to read all the accused or just one?
And 4 others.
And 4 others.
And what's the postponement date? Or the
It will
remand
be
date?
this coming Wednesday, my lord. Just provisionally, we will arrange a date on Wednesday. When
What is Wednesday's date?
That will be the 20th, my lord.
April.
We will request that we appear in front of you again in view of the fact that 2 of the accused in that matter are also before you. If your lordship is not yet finalized the matter before you.
But it's obviously not going to run in
It's
front.
not going to run, definitely not. Just a question of making all the
So
logistics.
will you by then have a trial date for when it,
By then I will have a trial date.
for when it will run?
That's correct.
And are the accused to remain in custody?
That is correct, my lord.
Thank you, my lord. I feel now case number 1, 2, 3, and 5 in that matter.
Yes.
I
1, 2,
confirm
3,
that
and 5. 1, 2, 3,
and 5.
and 5. Who's for 4?
Mr. Alexander, my lord.
Mr. Alexander.
I likewise confirm this arrangement should same be suitable to you.
And there are only the 5 accused.
Confirm that.
Sure. My lord, Mia is number 1, Mafunda number 2, Memela number 3.
Just wait, just wait. Just wait.
These are the 5 accused in order.
Right. These are the 5 accused. Are they in order from my left to my right?
To your
1,
right.
2, 3, 4, 5.
That's correct, my lord.
Yes. Accused may be seated.
As previously indicated, my lord, State requests, because with the blessing of the defense, that the matter be rolled over until Wednesday, the 20th of April, provisionally for the court to be arranged for trial, or if accused are in custody.
Thank you, my Lord. I confirm the arrangement with respect to 1, 2, 3, and 5.
Likewise, my Lord, on behalf of the accused number 4.
Will you tell the 5 accused that this matter cannot proceed today? And that a provisional date, when a date for the hearing will be announced, has been arranged as being Wednesday. That is Wednesday, the 20th of April, when they will be brought back to this court. And that on that date, the state and their legal advisors will have agreed a date and an arrangement will have been made when the trial will proceed. So when they come back to this court on Wednesday, the 20th of April, that date will be announced and the matter will further be remanded. In the interim, all the accused are to remain in custody. Right. So I make the following order by consent between the state and the legal representatives of each of the accused. The matter is remanded until 20th April 2016 in this court. All the accused are to remain in custody. Yes.
Ninking ukuthi ejele ngihlala kulona bangixoshile ne-exercise angisayitholi nokudla ngisakuthola visit bathe ngingabe ngisabuya.
Well, my Lord, my problem is that the prison which have been incarcerated I've been now chased away and I've been told not to come back to that prison again. I'm not even allowed time to exercise, my Lord.
Tell accused number 3 that he must raise whatever his problems are with his defense counsel and that the defense counsel will deal with it in due course.
Well, my Lord, I'm unable to go back to Krugers of prison because I've been told not to come back to Krugers of prison again.
Well, I don't know who told you that, but my order overrides whoever
I won't be able to go there, and I'm not leaving this dock currently, my Lord.
Well, I invite you to leave the dock, failing which there will be sanctions made against you. Tell him he must go. Right, so the accused may all leave the court. Counsel for accused 3, will you speak to your accused about the issue?
I believe the security issue is just an issue, but I will go during the team.
Whenever you like.
One and 4.
Accused number 1 and 4 men remain.
Right. So now we don't you met Mr. Mashiani.
Indeed, my lord.
Right. Two accused may be seated while the other accused come.
We're live in court now with Krejcir and murder co-accused in court from Johannesburg in Gauteng. Now, as you saw there, a very brief appearance with the 5 other co-accused that Krejcir was. As you know, he is currently facing 9 charges along with Siboniso Mia, Nkanyuso Mafunda, Simpiwe Mamela and Layobemir Grigorov. Now, Krejcir, as you know, was sentenced in February to 35 years in prison for kidnapping, drug dealing and attempted murder. Now, he is expected to apply for leave to appeal the conviction and sentence on Friday, but the judge has remanded this particular trial with the 5 co-accused to the 20th of April. That means on Wednesday morning, where the legal teams have agreed that they will then get together and decide on the due date for the trial to start. And as you see there, there's another case coming up right now, and we'll go back live to court. Well, it seems like they're still waiting for the other accused to come up from the bottom there. And as you can see, it was drama earlier on when the judge, accused number 3, indicated that they chased him out of his cell and he doesn't want to go back. He wants to stay in the dock. He's not going to leave the dock, he indicated. And the judge indicated to him that he should speak to his defense team and not to the judge about this matter. And there, of course, the drama unfolded where eventually he left the dock. And right now, Radovan Krejcir and the co-accused is waiting for the others to come up for the judge to take them through their paces there. As you know, this is the case of Radovan Krejcir and the murder accused, which is currently in court for the issues of drug dealing. There's also kidnapping and attempted murder. It's an ongoing case, and we're going to keep you posted as to what is happening there in court on a regular basis. We'll also try and find out from our reporter at court what is happening outside a little bit later, so you'll have to stay tuned. This is one of those cases that you don't want to miss. There's a lot more stories that we'll cover here, and we're also asking you a question in relation to advertising, a little bit on the lighter note today. Advertising and, of course, the black creatives, what it means for them, that they be included. All the vernacular adverts have now been included into the Pendorang Awards, which makes a great move there for advertising in the country, where indigenous languages are now being included. Let's go back live to court.
Yes, my lord, I've just sent some of the security personnel to make sure they hurry up.
Yes. Right. Now, while we wait for the judge to get ready for the next issue there on the court roll with Radovan Krejcir, let's continue with your news.
All the accused may be seated.
Yes, the court, please, my lord, be allowed to call the matter case number as 026 of 2014. State versus Krejcir and 5 others. I still appear for the state in this matter.
Yes. Who appears for number 1?
I appear for number 1. My name is James Grant, briefed by Alexander Montero, attorneys.
Briefed by who?
I have been briefed by Alexander Montero, attorneys.
Accused 2.
May it please the court, my lord, I appear on behalf of accused number 2, together with Mr. Buthelezi, Advocate Buthelezi and Advocate Satini, on instructions of Ramsey Weber attorneys. As the court
So you've got 2 juniors?
Yes.
I didn't hear the name.
It's Advocate Buthelezi and Advocate Satini.
Steeny.
Satini.
Thank you.
As the court pleases, my lord.
3.
May it please the court, I still appear on behalf of accused 3, 4, 5 and 6.
3,
4, 5, and 6.
All of them up to 6.
Up to 6. And I'm still instructed by Spanner
Right. So,
My Lord, I understand that today is scheduled for application for leave to appeal. We are ready to proceed. I understand, however, that some of my colleagues are not ready to proceed. I wonder if Your Lordship would like to hear them first.
let me hear them.
We are ready to proceed in principle, although we've been instructed to deal with certain special entries. In that regard, however, there's been an issue contacting the previous attorney of record to depose to an affidavit. I have, in the meantime, discussed the issue. I know Mr. Spannenberg is first going to deal with an application, or at some point, that we will fall last in queue in order to obtain this particular affidavit, and in the meantime, the rest of the accused can proceed with a leave to appeal.
So you just want to argue out of sequence?
I beg your pardon?
You want to argue out of sequence?
As the court pleases, my lord.
Yes.
With leave of the court, of course.
Oh. Spannenberg?
Lord, yes, I also wish to bring a application for leave to appeal. And coupled with that, and the Act says quite clearly, I wish to bring application for leading of further evidence. Actually, it's a. I bring it under that heading, although my submission will be at that stage when I argue that the evidence has already been admitted. I just seek an order that the evidence be admitted for purposes of leave to appeal and for appeal if leave were to be granted. But that application, in terms of the Act...
so you're not asking for leave to argue in some different sequence than the normal sequence? In other words, you'll argue whenever it is at the end, or subject to Ms. van der Neer for arguing after you?
I have no problem with that.
No, I'm asking you. It's a question, not a directive. What are you telling me is what I'm asking you.
What I'm saying is that when I argue leave to appeal, I will also argue the admission of further evidence.
Right. And should that issue, which you say is already dealt with, not cogently be argued as a first issue, because presumably if additional evidence is advanced, it was admitted, or is already admitted, then the other accused will want to rely possibly on that evidence.
Yes.
Or at least, let me put it this way. The question of what the evidence is should be finalized before the leave to appeal be argued.
Yes, I think it's...
So does that not logically put your issue first? That issue?
I'm in the court's hands.
I'm asking you.
Yes.
It's a question.
Well, the Act says that at the time of bringing the
leave to appeal,
at that point in time, application should be brought for the leading of further evidence.
Right. So I don't hear anyone saying they want to argue after you. So you'll argue in your normal course?
I will argue in the normal course.
Right. So then, and you wish to argue, is it last or at least?
I would like to argue last, my lord.
Last.
With
all right. And does everyone agree to Ms. van den Heever's argument being out of sequence and last? It doesn't affect you, but it might affect you.
Not really.
It doesn't affect you. So you're agreeable to that sequence?
Yes.
So we'll run the trial, all the issues concerning 1, all the issues concerning 3, 4, 5, 6, and then the issues concerning 2.
Yes.
Everyone agreed to that procedure as far as the defense is concerned. Right. Let me just hear from Mr. Mashiani. Mr. Mashiani, do you have any objection to that procedure being followed?
None.
So we'll run 1, 3, 4, 5, 6, and then 2.
That is so.
Okay. Right. I received heads of argument, I think, from you.
That's correct, on Friday, Monday.
Right. Have the other counsel been given copies of your heads of argument?
They haven't, my lord. My learned friend, prosecutor, has.
Ms. Van der Merwe?
No, we've not received any.
And do you want to receive it?
I have received.
You have now
I have
received
now received, my lord.
Okay. Right. So are we ready to proceed with one? Okay. Right. I hear one. This is an application for leave to appeal?
Correct, my lord.
Right.
Leave to appeal against the 3 convictions and the sentence, my lord.
Against all convictions and
all
all
convictions
sentence.
and sentence.
Right.
We will submit, my lord, that your lordship made errors of fact and law in respect of all 3 convictions and in respect of the sentence.
Yes.
Our argument is broken down effectively into 2 parts. First, procedural grounds, and secondly, substantive grounds. If I may commence by addressing your lordship on the procedural grounds, this again is split into 2. First,
Just that, they're procedural and substantive?
Yes, correct. Procedural grounds and substantive grounds.
And procedural is divided into 2?
Correct. Evidentiary.
As per the head?
Yes, correct.
So you intend proceeding through your head?
That's correct.
So I've read the heads. And
if
you
you
may carry
would
on.
prefer that I
Procedural
am more brief than...
I'm not telling you what to do. You may do whatever you feel proper.
Thank you.
I'm just telling you that I have read your heads.
Right. As you will note, that I have broken the procedural grounds
And I'm
down.
grateful to you for having prepared them in advance to enable me to prepare myself.
Thank you, my lord.
Right.
If I may, at this time, before I begin my evidence, hand up a case pack of authority. I've extracted from the cases the relevant pages only and highlighted only the relevant passages.
Thank you.
I've also furnished my learned friend, Mr. Marciani, with a copy of this. In respect of the procedural grounds, my lord, the first issue that I wish to address your lordship on is the standard of proof adopted by the court in convicting the accused. And if I may, my lord, I will be referring to the accused as accused number 1 as the accused, if I may continue to do so. I wish to address the court on the standard of proof adopted. It is our submission that the standard of proof adopted in convicting the accused on all 3 counts was far lower than what is required in a criminal case where proof beyond a reasonable doubt is required. A careful analysis of the findings of your lordship in respect of the convictions reveals that your lordship made 17 findings on the probabilities and a further 6 findings only beyond a reasonable doubt. Those findings beyond a reasonable doubt, my lord, are in turn reliant on your findings on the probabilities and are therefore also, unfortunately, not proof beyond a reasonable doubt. If I may read into the record the findings, the 17 findings on the probabilities.
They're the ones in 11.1.
They're the ones in 11.1, and your lordship may note that those that are underlined are the ones that are directly applicable or in some way relevant to accused 1.
Well, I've seen them. I understand what you're saying.
Right.
We have a different approach to the matter.
Yes.
My view is that the probabilities are relevant to the question of the determination of individual facts. You disagree with that, and I understand your submission.
Thank you, my lord. I will...
so you needn't, from my perspective,
yes,
go through each of these.
Right. If I may then, my lord, I will move on to the essential point of whether it is permissible to rely on mere probabilities in establishing anything beyond a reasonable doubt. Your lordship is, of course, correct that there are circumstances in which this is appropriate. You'll see that I've referred your lordship in footnote 28 to the case of R versus de Villiers.
Just wait.
Sure, that's page 12.
Yes.
footnote 28,
Yes.
the case of R versus de Villiers. It is my submission, and I concede, my Lord, that there are circumstances in which it is appropriate to rely on mere probabilities. However, this is only appropriate when dealing with circumstantial evidence, where the evidence that is being relied on is compatible with each other, and where the evidence being relied on forms alternative bases on which to find a particular fact proved. This would also, of course, trigger the requirements, because we would be dealing with circumstantial evidence of R versus de Blom, and it doesn't appear from your Lordship's judgment that the requirements of R versus de Blom were adhered with, nor does it appear with respect from your Lordship's judgment that your Lordship was engaging with these facts as probabilities in line with what is permissible arising out of the R versus de Villiers approach. In addition, my Lord, I also wish to point out, if I may just canvass the matters where your Lordship made findings specifically beyond a reasonable doubt. Your Lordship found that Lukele identified accused one as the person who poured hot water on him.
Yes, well, you've set them all out in paragraph 14. Yes, I'll see them.
Sorry, it's important for my argument, my Lord. And also that accused one was mastermind in the proposed exportation of the drugs. I wish to draw attention to the fact that while your Lordship relies on Lukele as a reliable and as a reliable witness, your Lordship does not, in fact, accept all of his evidence. There is a point in the evidence of Lukele in the record at page 533, lines 18 to 19, where Lukele testifies that he was stabbed. Your Lordship doesn't accept that point, and therefore it appears that your Lordship does not accept all of the evidence of Lukele. In addition, the identification by Lukele was a doc identification, to which I will return later. This, I will argue, ought to have been excluded from the evidence entirely. In addition, your Lordship, while at paragraph 30 and 36 of your Lordship's judgment, you do express the view that you are prepared to rely on the evidence of Lukele as proved beyond a reasonable doubt. Subsequently, my Lord, at paragraph 44, you express the view that you only take his evidence to be true on the balance of probabilities, or on the probabilities. These two, my Lord, are of course inconsistent, and at that level of confidence it's inappropriate. That level of confidence is inappropriate in a criminal trial. It of course leaves the real possibility of a reasonable possibility that Lukele may well have been wrong. Furthermore, in respect of your Lordship's finding that it was proved beyond a reasonable doubt that accused number one was the mastermind controlling and in charge of the plans to export the drugs, this finding follows only on citing the relevant section, and the only other evidence or argument or finding in your Lordship's judgment to this effect is another finding on the probabilities to be found at paragraph 64, your Lordship. And so ultimately it appears that there is no link or no basis on which to elevate that finding, which originally is expressed in terms of the probabilities, to one beyond a reasonable doubt. Again, it appears that there's only probabilities behind that finding. Your Lordship, I also wish to indicate that right at the end of Your Lordship's judgment, at paragraph 126, Your Lordship indicates that Your Lordship's view of all of the events that took place was arrived at on the probabilities only. This, of course, would translate into an inadequate certainty for convictions on the criminal onus. And finally, Your Lordship, even if it had been proved on or beyond a reasonable doubt that every single requirement of criminal liability was in fact proved, Your Lordship was required then to apply the product rule to those probabilities, which is what is required whenever the coexistence of any two facts must be calculated. This has now been accepted in the case of S versus SB, 2014. I referred to it in footnote 42. This is the proper method for calculating the statistical probability of the coexistence of any two facts. The reason why this would be applicable, my Lord, is because in the case of criminal convictions, one is required to establish that all of the requirements coexisted at exactly the same time. The effect of that is to drive down the ultimate probability of guilt. I don't know if Your Lordship wishes me to address you on the product rule, which is somewhat of a statistical nightmare.
I understand it.
Okay.
I also understand it in the context of other evidence where accused come before me and say that because there's a 0.1% chance, therefore they fall in the 0.1% category. It's that theory, isn't it?
Respectfully, it's not, my Lord. I suppose the best example of it would be if one were to imagine a roulette wheel where the probabilities of the ball falling on red or black is 50%, the probabilities of a ball falling on even or odd numbers is 50%. It reduces ultimately, if you insist on red even, the probabilities of that happening is only 25%. So it's that astounding effect that we're asking the court to consider.
Yes, but when I look at it, I must look at the entirety of the sets of facts which I found and say if the sets of facts lead me to conclude X, then X is the answer.
The conclusion to which it drives, my Lord, I wish to submit, is in fact that all and each of the requirements for criminal liability must in fact be established at a higher standard of proof than merely the proof beyond a reasonable doubt. Because once you apply the product rule to the requirements, because of the effect of reducing the overall probability, in order for the overall probability...
Half times a half is a quarter. I understand the principle.
Yes, right. As court pleases. In respect of identification, Your Lordship was...
You're now on the separate, on a different tack.
Yes.
This is the doc defence.
The doc identification. That's correct, Your Lordship. Beginning at paragraph 19, where I begin my argument and acknowledge that Your Lordship did take account of the dangers of relying on a doc identification. It would appear, however, that Your Lordship's view in respect of the dangers posed by doc identification relate to whether the witness properly identified the accused on the previous occasion. I submit that the dangers of doc identification, as is set out in the various authorities that I've cited, relate not to the identification by the witness at the previous occasion, but of identification by the witness in court on the occasion of the trial.
Yes, well, there's a suggestion because he's the accused. Is this the man who hurt you? Yes, of course he's the man. That's the problem.
Correct. That is my submission.
Now, if there are other people that say it is the man, then that problem is overcome.
Unless, of course, my Lord, I wish to submit each of those witnesses only submit a doc identification.
And if I know you from before, and I have no problem, I don't have this problem of not knowing who you are. I know who you are. And now
Again,
identify you.
the question, my lord, is not whether the witness knows the particular accused. The question is whether in court it should be considered permissible by virtue of the fact that there's every indication and every suggestion that you are, as the witness, required to identify whoever is standing in the dock.
Yes, that's the objection.
Yes.
But if I know you from before, that objection falls away largely, unless I've got a hidden agenda. If I know you, the problem with the dock identification, I didn't really recognize you. They put you in the dock, and now I say it's you, even although I still don't really recognize you. That's the problem.
Correct, Your Lord. That
Now,
is
if
the
I know
submission.
you, I know you very well.
Yes.
And now they put you in the dock. The only suggestion is that it's the person who did the act.
Correct, Your Lord.
So it's not an identification issue. It's a question of complicity.
Even at a subconscious level is what is the submission that I would make.
I'm hearing
by
you.
virtue of the suggestions.
I'm hearing you.
Thank you.
As long as we understand each other.
Yes, thank you, my lord.
So that's the dock ID.
That's the dock identification, and furthermore, I also need to add to that the identification and the probabilities, or at least the certainty attached to the witness of Bukele by your lordship at paragraph, and ultimately at paragraph 4, was only on the probabilities. It's important, I would submit, to bear that in mind.
Yes, but I don't convict on the basis of Lukele only.
That is correct.
Yes.
If I may then turn to...
I say that his evidence appears probably to be correct in the certain respects that I deal with it.
Yes.
On the probabilities,
yes.
The probabilities favour his version.
Correct.
That's the point.
Correct, but that unfortunately...
And therefore,
yes.
It's not the test to find a conviction,
yes.
but it's relevant to finding a fact.
It appears from your lordship's judgment, I would submit, that is the extent of certainty
yes.
that you're left with. And when you combine that with the degree of certainty you express in respect of all of the facts at paragraph 126, you also indicate there only a degree of certainty on the probabilities, which is unfortunately inadequate in a criminal trial, I submit.
Yes.
If I turn then, my lord, on page 20 to the evaluation of conflicting evidence,
yeah.
It would appear that there was...
Just wait.
Sorry, that's at paragraph 28.
No, I just want to make a note.
Right.
Yeah.
Your lordship, it would appear that there was conflicting evidence, at least between the evidence proffered by the accused himself and several state witnesses to an extent, and that this required an analysis in terms of the prevailing authority in our law for dealing and resolving conflictual evidence. That standard is dictated by the case of Stellenbosch Farmers Winery. My lord, if I may draw your attention to the regrettable mistake I made in citing that case.
It's a well-known case, I know.
Yes, 2012.
Don't worry.
Apologies, it is in your pack.
Don't worry.
I wish to submit that the failure to engage and analyse these conflicting evidence, the conflicting versions, failed the prevailing authority. Furthermore, your lordship dismisses the testimony of the accused as to the possibility of a conspiracy or collusion on the basis that there was no evidence. I respectfully submit that this is not the case.
What was the evidence?
There was evidence, at least by the accused, which raised, I accept and concede,
based
only
on no facts.
It raised at least a possibility.
Well, what's a possibility got to do with
it?
It
required, in turn, that your lordship engage with it and consider whether there was whether it amounted to a reasonable possibility, which your lordship respectfully failed to do.
Yeah. I hear you.
My lordship, if I may then turn on to the second leg of the procedural grounds, the fair trial rights.
Fair trial.
Beginning at page 22.
Yeah.
Given that your lordship has had an opportunity to read the heads, I'll be...
Well, the physical restraints, that's the one thing you raised? During the trial, was he restrained? Was he restrained during the trial?
My understanding is that he was restrained at least during the sentencing, my lordship.
Well, what's that got to do with the conviction?
Point conceded, your lord.
Okay.
It was, however, most problematic during sentencing, and in particular because he was representing himself.
How would it make it worse?
I understand, Your Lordship, that he had trouble moving and
How
complained.
would it make it worse from my point of view that I would want to punish him more because he's restrained? I'd say, you're restrained, you must get a heavier punishment.
The authorities seem to indicate that it leads to the suggestion of dangerousness on behalf of the accused person, who at that point you would be correct in saying was convicted, and where dangerousness is, of course, a relevant concern. In sentencing, we would submit that it could have influenced Your Lordship in that respect.
Okay, I understand.
If I may then move on to the issue of consultation with legal representatives. In this respect, Your Lordship...
with regard to conviction or sentence?
With regard in particular to sentence.
Well, you must choose.
With sentence.
A or B?
Apologies, my Lord.
Sentence. Yeah.
The time,
Consulting.
there were time limits placed on consultations.
My recollection of his statement of fact before me was that he had met 4 times with someone who was going to give him a report on sentence and spent some 100 hours with him.
I understand that's a witness, my Lord.
Well, that's him. He said that during that period he'd been able to do this. So if during that period he could do that, why couldn't he speak to his representative during that period? He could. He said, I just have an intellectual problem with that.
I concede. I do wish to, however, bring to the court's attention...
Anyway,
that
I've read this, I understand it.
All right. And then perhaps, as the court pleases, I should move on to the adduction of evidence. The adducing of evidence.
Adducing of evidence.
Page 25.
I'm there.
Here in particular, I wish to draw to the court's attention the duty that falls on the court in respect of an unrepresented accused person, and also that a duty falls on the state to assist an accused person in order to produce their witnesses. My understanding was that this support and assistance was not given the accused in the sentencing. May I proceed?
Yes.
If I can now turn on page 26 to the substantive grounds.
Go this way.
I'll deal in turn with each of them in order of conviction. Dealing in drugs. Your Lordship correctly identified from the section, and also the fact that in order to be convicted of dealing in drugs, it must be proved against an accused that the substance that the accused intended or attempted to deal in was indeed the substance that was dealt in or attempted to be dealt in. However, my Lord, it raises the problem that in the absence of intention in respect of this particular substance, there can be no fault as required to extend to the element of the particular substance.
I don't understand.
The fact, as Your Lordship recognizes, that the substance in question must be the substance which the accused intended to deal in. So if the accused believes it was methamphetamine, it must be methamphetamine, and the state must prove this against the accused. It's elevated to an element of the crime. As such, and on the basis that our criminal law requires that intention or fault must extend to every element of the criminal offence, intention must have extended to the fact of it being methamphetamine.
Prohibited.
Not simply a prohibited substance. Our submission is that intention must have extended to it being that particular substance, methamphetamine, my Lord. And Your Lordship...
Well, they're not separate issues. The first issue is that he knew that it was the drug.
That is correct, my Lord. I'm taking the second issue.
And now he dealt in the drug.
Yes.
Now you say the fault issue.
The
He
fault
must know
issue.
that it's the drug.
Correct. And
Yes.
in respect of that, my Lord, in your judgment at paragraph 107, you indicate that in fact he had no knowledge of that drug, you do make recourse to dolus eventualis in the
I'll
circumstances.
say there was no proof that it was that drug directly admissible against him.
Yes. To quote your Lordship, accused number one, knowledge is limited to the bags containing a prohibited drug, and
Yes.
that is all that may be admissible against him. That is correct, your Lordship. It was not proved by the state against him. The problem arises,
From
however...
that, now the question is,
Did
where
he
do we
know?
go from there?
Yes. The difficulty, of course, which arises is that his knowledge must extend to what the drug is. Given that the state couldn't prove it, we are left with the...
The state proved there was a drug, particular drug, on my judgment.
Yes, but that he didn't know it. The only question
No, that it wasn't proved that he knew what it was directly.
Yes, you do resort then to dolus eventualis. I wish to address your Lordship I wish to address your Lordship on your resorting to dolus eventualis. You do resort to finding that by resorting to dolus eventualis, it could be found that the accused may have known that it may be that substance with which the accused is charged. I respectfully submit that this is an improper use of the doctrine of dolus eventualis.
I'm not sure I do that. I'll say if he's participating in an activity which involves that particular drug, but because of the particular mechanism by which evidence is admissible against him, excluding that directly.
Yes.
Therefore, the question is it proven that he participated in it as an attempt? If he intended to deal in that drug,
yes,
which the other objective facts show,
yes,
but it's not proven that it was exactly that drug in that bag,
yes,
then it's an attempt.
I will come to the issue of attempt if I may in a moment, or unless you wish me to address you on that.
Isn't that what the issue is?
I think we can separate them out and deal with the issue of intention to commit the offence. Thank you, Your Lordship. I would submit that it would be the question, the appropriate question, if one was to resort to asking dolus event whether there was dolus eventualis, would be.
I don't think it's a dolus eventualis issue. Anyway, I'm hearing you.
Your Lordship does refer to dolus eventualis at page 108 in your judgment, and I would argue that would be improper. But if I may then turn to what does seem to be an issue, whether it would have been appropriate to have convicted him of an attempt at the impossible here, it does seem from your Lordship's judgment that your Lordship treated this as an attempt to commit the factually impossible. I would submit that given that the substance was unknown to the accused, and on the basis that it is an element of the offence that the particular drug must be known to the accused, that this is in fact a charge of attempting to deal in an unknown substance, which is not a criminal offence in South African law, and would therefore render this an attempt at the legally impossible, which is not punishable under our law.
I understand the argument.
Thank you, my Lord.
The same argument we had at the trial.
I don't know if there's anything in particular there that you would like me to address you on in respect of that issue. I do see that your Lordship relied on the judgment in the Ndlovu case, saying that in that case a conviction was handed down on a similar provision. I respectfully submit that that case is inapplicable. It was concerned instead with whether an attempt was appropriate for circumstance crimes, and didn't deal with impossibility in the same sense as is understood in the case of Davies, where, for instance, there was the question of whether it's possible to attempt to kill a fetus which is already dead. I don't know if this carries anything further, or if your Lordship has any question. Okay, I'll move on. On kidnapping, your Lordship, it would appear that despite the requirements of kidnapping requiring at least intentionally depriving another of his or her freedom, that your Lordship didn't in your Lordship's judgment indicate the conduct element nor the intention on behalf of the accused to commit this crime. It is therefore not clear on what basis your Lordship could have convicted the accused of this offence. One further point does require to be made in respect of this, and it would also be applicable to the attempted murder charge, which is that if your Lordship was indeed relying on some form of attribution of conduct, this is of course not in my head, at least not in respect of attempted murder, if your Lordship was relying on a form of attribution, excuse me, my Lordship, if I may just have a sip of water. If your Lordship was relying on a form of attribution such as agency or common purpose, it would trigger the requirement set out in S versus de Blom 1977 Appellate Division, where it would be required of the state to prove that the accused knew that by that conduct, through others, he may be held to be criminally liable. And there was no attempt on behalf of my learned friend to do so. Shall I proceed? In respect of the conviction of attempted murder, again, Your Lordship, I wish to submit that Your Lordship failed to identify the conduct by which the accused committed attempted murder, and furthermore failed to identify the required fault requirement in the form of intention, and that indeed...
If he was the person pouring the boiling water over the person who was kidnapped,
My Lord, it appears from the
would that
judgment
be
that
lawful?
there is...
Would there be any doubt that it's unlawful?
I don't believe this is a question of unlawfulness, my Lord. It's a question of intention.
Is there any doubt that if you pour hot water over someone's head, you intend
to kill them?
Yeah.
I submit there absolutely is.
You submit that?
I submit there must be reasonable doubts at the very least as to your intention to kill that person. I think we're in agreement then.
We're not.
Well, at least we understand. At least we understand each other's arguments, if I may submit, my Lord. On sentence, Your Lordship, my Lord, apologies. Very brief points. I submit that Your Lordship, for the reasons that I've indicated earlier, failed to hear the accused's evidence and failed to take account of the differences in personal circumstances and the gravity of the various offences, and therefore arrived at a sentence which, in another court, would be regarded, I submit, as shockingly inappropriate. And that in another court, even if the convictions were confirmed, we submit that another court would indeed impose a far lighter sentence. In conclusion, my Lord, we submit therefore, I won't cover the ground on the sentence again, but in respect of all of the arguments on the convictions, we submit for those reasons that the accused enjoys a reasonable prospect of success on appeal, and we ask for leave to appeal on the convictions and sentence.
Thank you.
Thank you. Please.
Thank you. Lord, if I may deal first with the accused application in terms of section 316, 5 and 6. That's for dealing with the further evidence. Lord, I have
3165 and 3166.
6. Lord, I have an affidavit, notice of motion affidavit as required in the Act, as well as short argument. Am I hand it up?
Thank you. Yes. Have you seen this affidavit? Have all the other councils seen the affidavit and the documents? Do you want to see them? Well, perhaps you should.
We would appreciate that.
Yeah, perhaps you could.
You see if I have a spare.
Okay.
Lord, the further evidence is contained in exhibits SP 10 and SP 11. These are the
issues in paragraph 8.
Well, I
mean, that's from reading your affidavit.
Yes. I deal with the whole of the affidavit.
But that's the nub of it.
Yes.
So what, he was not sure of the roles? They were all wearing jackets with hats, covering their heads. It was night and the lights were not on. And Mofa King, number 6, showed him an SAPS ID card. Those are the points?
Yes. It's in the reports. My Lord, these reports came at issue, or in issue, at sentencing stage, where the state wanted to hand in, particularly the victim impact report. An agreement was reached between the state and accused, in fact all the accused, but in particular accused 3 to 6, that these reports can be handed in. And the words being used, and I think my learned friend for the state still confirmed the admission, that the evidence is factually correct and the acceptance of the opinions therein contained.
Well, it's what I traditionally ask everyone, because do you accept the facts, do you accept the opinions, and do you accept that the opinions are apposite?
Yes.
Because those are the requirements for the opinions.
Now these
but it obviously dealt, and this is my understanding, this is where there seems to be some other issue. Did those admissions not deal with the personal circumstances which were being presented, or did it cover all facts?
All facts,
All facts.
Certainly my intention would.
Well, your intention, but I don't know if that was the state's intention.
Well,
that's the first question. Did the state intend to admit? And the second question is it binding on me? The admission.
That's my argument before you at this point.
Right.
My first submission is that
is the admission in sentence binding on me in relation to conviction, where I've already found facts. So if I find a set of facts and there's already evidence, what's the effect of this admission, which, let's assume, contains contrary facts?
As I understand the Act, my Lord, may I just make the first submission that this evidence is already evidence before you, Your Lordship.
Yes.
It's not to be admitted in terms of Section 316, but be it as may. What Your Lordship, as I gather from the Act, is now, with respect, obliged to do, is to consider this new evidence, and for purpose of appeal, if appeal does arise, for purpose of appeal, set out your finding as to whether this is really material, to what effect it affects the conviction, to what extent it affects the conviction.
So what must I find? To what extent?
It affects the conviction.
To what extent do these facts affect the conviction?
Indeed, sir, Lord.
And then, if I find it has some effect, if I find it has no effect, well, that's not a problem. If I find it has an effect, then what do I have to do?
Then that finding of yours is part of your judgment, which will be then dealt with on appeal.
So it's not a question of reopening the trial.
No, my Lord. There was the old approach.
That's my understanding of 316. I then have to go and rehear the trial.
No. What Your Lordship, the evidence before Your Lordship. Your Lordship.
Isn't that what the section says itself?
It's not a matter of reopening a trial. It's the matter of introducing the evidence into the record for purposes of appeal. Your Lordship cannot change your judgment.
I can, so I understand the authorities.
Well, that's the old authority. I think after there's appeal court decision in my head which deals with that.
I don't know. Where's the words? Did I get them?
I think it's...
Just wait. Q's 3, 4, and 6. In the heads you've given me now?
Yes.
Let me just look at it, because I haven't read them. Just wait. In your heads now, paragraph?
My Lord... paragraph 24, my lord.
24. Just wait.
That was
Just wait. Just wait. Yeah. Just that this is a different issue. Which judgment do you say is the one that says that I don't have to reopen and hear the whole case again?
I think it was suggested in Fisher, my lord.
In Fisher?
Yes.
What weight do you suggest I should apply
Well,
to what is patently a hearsay statement, untested? One doesn't know the circumstances in which it was given. I'm just raising these issues.
Well, my lord.
In relation to actual evidence, which I heard, flesh and blood witnesses, and where decisions are made. So how do I treat this? Assuming that it's conflicting.
As you treat any other admission, my lord. Or
Listen, how do I test it?
as you test any other admission, my lord. It's there. The state and the defence has made admission. The act has since changed the
Not in relation to the conviction.
Yes, my lord. There's facts before you. There's an admission in regard to the factual content of those statements.
Yes, in relation to the sentence.
No, yes,
Well, it was obviously in relation to sentence, not in relation to conviction. That's why I'm raising
but
with
it also
you.
relates to conviction, my lord.
Well, I don't know. That's why I'm raising with you the extent of the admission.
It is there, my lord. The
Well,
only
no,
problem
you
is
can't
that
say it's there.
that is-
I need to understand the ambit of what was agreed, because it may be. Well, I'll hear from Mr. Mashiani.
Yes,
what the
indeed, my lord.
ambit is. Anyway, I understand all these points.
It's also in terms of the hearsay evidence. It's admission in terms of the hearsay.
You say it doesn't matter where it comes from.
It
It's
doesn't.
admitted.
It's admission.
Yes.
But in terms of the
I
hearsay,
don't even
admission-
need to have an evidence. I
Yes.
could just have an admission.
Yes.
Yes. No, I understand exactly what you're saying.
One can deal with that in terms of section 220. You can deal with it in terms of section.
Anyway, I'm hearing
3A.
220, but isn't 220? I'm not sure you can. That's a different issue. But what does 220 relate to? Is it admissions? An admission that one piece of a trial affects another piece. You know, with extenuating circumstances.
Yes.
An admission in the extenuating circumstances can't be used to backtrack onto the conviction.
No, my lord. You mean the old?
Yes, on the old system.
Our courts are. Van Wyck's decision is quite clear. And it's quite interesting. Moy is a distinction because Moy deals with an admission made by an accused during extenuation.
Yes.
And I submit that it will appear.
Which was prejudicial to him.
Yes.
Now that you don't take into account.
Because of his right not to incriminate himself. I think.
But now he incriminates himself voluntarily. I don't know.
But this is something that.
Does it say that? I don't think it says that.
Well,
in
it seems
case.
that Van Wyck deals within that.
Van
because
Wyck.
Van Wyck. It's a full bench decision. I can hand you up
just
the.
that will be useful. The merit in looking back on the appeal at the evidence as a whole, which includes the conviction.
Yes.
Well, I don't know, but I'll have a look. Let me have a look at it.
The two matters is Van Wyck and Moy.
And
Moy
Moy. Well, Moy is against you.
Not really, my lord. I suppose. No. Moy deals with an accused who incriminates himself.
Okay.
And it seems like Van Wyck does deal with the Moy situation because it says it actually refers to. It must be considered whether the accused is incriminating himself before this can be admitted. But Van Wyck deals with logic and says it will be logic and prudent to look back at the whole matter on appeal. In dealing with the matter on appeal, look back at the whole of the evidence.
Assume the accused came and he said something later. I couldn't use that to convict him. I couldn't say this corroborates my view of your conviction.
No.
Now
it can only be dealt with on appeal.
Yeah.
The Court of Appeal can say, well, we have this further evidence which was not dealt with by the trial court.
Now, On the issue of further evidence, the evidence has to be cogent, it has to be definitive of a fact, it has to be dispositive of an issue, it has to be apparent that it's not pinching the shoe, not a case of producing evidence that pinches the shoe, all these things.
Well, it has to be dealt with as evidence as usual, my lord. It's no
No, it's the question of the admissibility of it.
Well,
whether you admit it. You say it's admitted.
Yes, my lord.
In the conviction.
It's admitted as evidence. What I'm asking for, my lord, is that be considered as part of the evidence on the application for leave to appeal, and that it will be considered.
No, I understand that.
Yes.
But how you get there is a different issue.
My lord, it's there by admission of hearsay evidence. The parties agreed.
On what point was an issue? When you reach an agreement to admissibility, you reach an agreement to admissibility on issues that are before the court at that time. At that time, that wasn't an issue before me.
The report was an issue, my lord.
No,
the report is before you.
No,
we
the
admitted that the whole of the report can be handed in as evidence before your lordship.
I understand the submission. I'm hearing you.
My lord, I don't want to argue my learned defense case, but if he wants to withdraw admission, then he must do so. And we know the evidence.
He'll come and give me his complaints or otherwise.
But my submission is it's there. It doesn't need to be dealt with in terms of section.
Did you say to him pertinently at the time of the agreement, listen here, I'm going to say that once these points are admitted, if you intend admitting them, that this means that your case is, let's call it just for shorthand, rubbish on those points.
There's even case law. If accused makes an admission which is partly to his benefit, and the state just stands by and accepts it, it's a waiver. There's a case matter there that says the accused.
Well, there are other cases that say that where there's disputes about what the facts are, I mean, assuming that there are these disputes, that you need to have them dealt with at the time of the admission. So, in other words, people need to know what the ambit of the admission is.
The Lord of the accused makes confession. He relates a certain occurrence.
No,
he admits his guilt. It's a fait accompli once it's before your lordship. He can't come back later and say, I made a mistake, which often accused would like to do. But that's not in his hands. He must.
No, but it's the legal representative. It's not the witnesses that's making the admission. It's Mr. Mashiani.
Yes.
So let's assume he's half asleep when he doesn't read that section, that word. Is he bound by it?
But
do you intend him to be bound by it? That's the question. Yes.
He made the admission.
Understand.
And he has to apply to withdraw the admission.
I'm not sure he has, because I'm not sure that that's an issue. But we'll come there.
My lord, but we're missing another point here. It's the truth, my lord.
The truth.
The truth.
The truth.
Being what? Being two opinionated people saying that Lukele said, now turns around and says, accused Six is the one who showed the ID document. He's the one who was there. We're dealing with it. Should we just deal with the truth? With a statement by two independent people. It's not a matter of, we're not playing a game.
It's like these assessors' reports, where they come and describe the action, and they're only there to deal with the car that's broken. Now they gratuitously describe the collision.
Yes.
Now, if you admit that, it's obvious that they intend, in my view, potentially obvious, that they intend to deal with whether the car's broken, not how the collision occurred.
Yeah, my lord, but both these witnesses intended to get a statement of the occurrences on that night from this witness.
Well, why didn't they get a proper statement? A bigger, longer,
They are proper, my lord. Lukele's statement is 2 pages in detail, which, interesting enough, is factually the same as his evidence, except for one point. He now points accused number 6 as the person.
As the ID of, as the producer of the document.
Yes, my lord. Yes.
Okay. I hear all that.
Lord, so my submission is, it's the evidence is before you. It's not that at this stage I'm applying
in the wrong
for evidence
context.
to be brought to court. It's before you. It's not strictly a 316 application.
Okay.
And
So it's
As long as that admission stands, it's before you.
right.
And you must deal with the weight of these statements.
Yes.
And that is required of you respect to deal with it in your judgment and indicate to the Court of Appeal what weight you attach to it.
Only if I'm going to allow more evidence led. But if you, as you say, it's already before me, I don't have to do that.
It is. I seek an order, my lord, a declarator, so to speak.
No declarators. You're not entitled to declarators.
Well, my lord, then.
You're entitled to what the section says, which it says, if I'm going to admit it, I have to do things.
No, but my lord,
if it's already before
in terms,
me,
if it's not new evidence in terms of section 316, I say this evidence.
Well, in other words, you want some relief. Which section entitles you to?
No, I want an order that your lordship finds that this is evidence before you.
Well, what gives you that right to demand that?
My lord,
what section gives you that right to demand that relief? You can't just come to court and say you want something.
No, because I'm going to argue to your lordship that this is evidence which you should consider.
Well, that you can argue.
Fine. As a good basis.
But you're not entitled to an order from me that it's X, Y, or Z.
Lord, I have the difficulty in arguing leave to appeal without knowing what your order is concerning this evidence.
Well, that's your difficulty, not my difficulty.
Well, I beg you to assist me, my lord.
No. I follow the rules and the law, and if you point to the law, then I make orders in accordance with the law. I don't pro tem see such a law entitling you to declarative.
Well, perhaps, Lord, my approach is that we deal with this issue before I deal with my application for leave to appeal.
This issue. So you want Mr.
Yes.
Mashiani to argue the matter? Why should he argue? Why shouldn't you argue your whole case on the pleading over and arguing over concept? I think you have to. I think you must argue your whole case, get finished, and we'll hear Ms. van den Heever, then we'll hear Mr. Mashiani.
May I do so after tea, Lord?
Is it tea time?
Yes.
Yes, court adjourned.
All right.
The accused must go down.
What now? I said yes. I need to take a medication. So you cannot stop me to take a medication.
Effectively, yes. Think so?
Tell me now, did you get that advertisement? Yeah. The email I sent you. Thank you. Okay, thank you very much.
Mashiana, where's the court orderly?
My lord, I've seen one of the officers had gone down.
Can the court orderly please see where the accused are?
Special. VVIP.
Section 12. Accused may be seated. Spanning back.
Thank you, my lord. Lord, might I hand up my notice of application for next week? On behalf of accused.
Does everyone have copies of it?
Mr. Johannes has.
Okay. Right.
Thank you, Lord. Lord, the notice is much the same and deals with the same issues as in my heads of argument on conviction. If I may just highlight a couple of aspects, my Lord.
What is this thing? Application for leave to appeal. Is this application not the heads? Oh no, this is the actual application.
Yes.
Okay. Yes.
Thank you, Lord. Lord, I firstly deal with Mr. Lukere's doc identification of accused number 4.
Yeah.
And I've dealt with these aspects, I think, my third time now, after including a 174 application.
Yeah. So they're the same issues.
It's the same issues, my Lord, except if I may refer to your judgment. In your judgment, my Lord, you found that...
Paragraph?
33, my Lord.
No, I mean in your notice.
Oh, I beg your pardon.
Is it this 1.13? This series of...
Yes, 1.2 and further, my Lord. I deal with
1.2?
Yes.
Okay.
Your Lordship found that he had identified accused number 4 correctly. In fact, he hadn't, my Lord. He described him as a tall person, and his facial features, I submit, also differs from the actual features of accused 4. So his identification wasn't, his description wasn't correct. A particular description he gave in his witness statement. It's not a correct description. I submit with respect also, Your Lordship, Erden, as far as the lumberjacket issue is concerned, as I understand Your Lordship correct in paragraph 33 of Your Lordship's judgment, the fact that he had failed to deny, he only denied that he was there. He did not deny that he had a lumberjacket. Lukeli says he was wearing a lumberjacket. As a corroboration of Lukeli's evidence, I submit that
it's a small point, but it's a point.
My submission is a non-point with respect.
Right.
Another court may well find.
No, I hear you.
Thank you, Lord. Lord, he also said to Captain Ramahala he wouldn't be able to identify anyone. That's why no ID parade was held.
But that was in the context of having already said certain things.
Yes, well. And also in paragraph 33 of Your Lordship's judgment, you find that he correctly identified accused number 4 as a policeman. There's no indication in his evidence, it wasn't listed at all by the state, why he said he was a policeman, except for the identification card perhaps. That is how it could have been anyone's identification card. It doesn't say, his evidence not that he read the name, of course, that's never been the evidence. So that's also a non-point. It doesn't take identification any further.
Well, except he is a policeman.
Yes, my Lord. It doesn't take identification any further.
Well,
I submit it.
I say you're X type of person, and you are X type of person, and I say I identify you, then it's some way down the road.
But it's a non-point because it doesn't say why he knows he's a policeman. It doesn't matter any further. Therefore, any policeman could be a suspect on that point.
Well, it's the feathers.
Even Lord, but it's a non-point.
Well, you start with one feather, then you get another feather, then you've got a duck.
Yes, Lord, but if you still lack a feather, then you haven't got a duck yet. Yes. And I'm saying it still lacks a feather.
I'm hearing you.
There's no duck yet.
We report whether it's a duck or not.
As a court pleases. Lord, if I might deal with Mr. Matabele's evidence. His evidence must be considered with some care, particularly as far as the identification of accused 34 and 6 is concerned. Mr. Matabele never testified that he saw any of the accused going to Ermelo. The first time he saw them is when they arrived there. He then testified in chief he saw 3, 4 and 6 alighting from a vehicle. And a cross-examination is put to him, he concedes. He says it was 50 meters away, it was dark. Then he says...
You mean at the place?
At the place. Then there's the issue...
That's in response to me, I think.
Yes, indeed it was. Then there was the issue about the motor vehicle not starting, the Vita.
Yes, and then they all came and they had lost the key and found the key and all these
But that's
things.
the point, who came?
Well, who did?
Well, we don't know, my Lord.
Well, it was the people who were there. Who else would have come?
Yes, but who were the people who were there?
Well, if he says that you were one of the people who were there, he saw him in A place and B place.
No, but he didn't see them. He only saw them when they alighted initially. He didn't see them beforehand. Then he said, the people who were in the Vita then approached. Who are these people? We don't know, my Lord. There's no evidence where they were.
Well, who were they? Who does the state say? What does the evidence say they were?
He says...
The other evidence says what they were.
Matabele, Mr. Peter. I'll deal with that now, my Lord. But he doesn't say. His evidence that he saw them alighting comes to naught. So, consequently, the house of cards then tumbles.
Well, what's wrong if I say, I saw someone getting out of the car and someone else comes and says, that someone is George? What's wrong with that?
Yeah.
It means I don't identify him,
but he
is identified as being George who was there.
Yes, but I'm dealing with Matabele there.
Yes, but you can't look at one person alone.
We'll deal with this. We can deal with that now.
Okay, anyway.
The fact of the matter is, He cannot say.
He doesn't say.
There is no evidence to say accused 4, particularly accused 4 and 6 apply. He doesn't say that because he never saw them. He says they never saw them. Because his evidence that he saw them alike, as in that evidence on his own admission. He didn't see them alike. So he didn't, except for Peter, he saw no one. Now we're dealing with Peter's evidence. Peter. The 4 and 6 were never present during the discussions about going to ownership. Mr. Matabula conceded that accused number 3 left just prior to these discussions going to ownership. The evidence is quite clear. Mukele was taken from the officers and put into a BMW vehicle. The other vehicle, the Vito vehicle, which contained, according to the stage version, the 3 accused, had already left. He never alighted from that vehicle, Mukele now. There's no evidence, for certain, no direct evidence, that they knew he was in the car. Only evidence the state can rely on is circumstantial evidence. But even that is not sufficient. He never alighted, they never saw him from leaving until arriving in Ermelo and coming back. So there's no evidence that they were part of a conspiracy to take Mukele to Ermelo. There's no kidnapping portion. At least, he doesn't point out accused number 6 as being there with himself. He fluctuates on that issue. But eventually he doesn't point out.
That's the attempted murder.
Yes.
Okay.
Back to Katlehong, my lord. I'm jumping the gun a bit.
Okay.
There's no evidence that accused 3 and 6 was at Katlehong. Particularly as far as accused number 6 is concerned, He's not even placed in the vehicle at the Sassel garage at Dublin. So there's no evidence he was there. So he could not have been as well not been involved in that portion of the killing. Only evidence is that accused 3 was in the car, as recognized by Peter. That, of course, the inference can be drawn that he from there went to Lukelia's house, but it's not the only reasonable inference that he was in fact there. There's no other evidence that takes him to Lukelia's house.
So that's the diploma argument.
Yes.
First counsel.
Yes. There's no evidence. It's an inference. But is it the only reasonable inference? I submit not. Lord, as far as the attempted murder is concerned, I argued this before as well. They did not have the intention and could not have the intention to have murdered Mrs. Lukelius simply because they needed him alive. They were questioning him, they wanted information from him. The pouring of water over his head was not to kill him off. It was to, on the stage version, to obtain evidence, to torture him and to obtain information from him.
And what if it would kill him?
In this murder. Dolus eventualis. But it didn't kill him, and they didn't want to kill him. So they didn't
What
want...
if they don't want to kill him, but they do things which they subjectively, reasonably foresee could result in his death?
A couple of homicide.
No.
Yes, my lord.
Sorry, subjectively foresee, not reasonably. They subjectively foresee can result in death. Even though I don't want to kill you, look, you might die, but I'm trying not to kill you.
It's not murder, my lord.
It's murder.
No, my lord. There's no intention to kill. I'm trying to injure you.
It may not be a direct intention.
It could, at the most, it could have been a couple of homicide. If he had died, it would have been a couple. There's no intention.
That's not what I'm saying.
Well, then couple of homicide doesn't exist as a.
Well, it doesn't really exist very strongly.
Yes. There was no intention on the behalf. It's quite clear.
Well,
another court may
give them an intention that I feel is the correct intention.
That they wanted to kill him.
Yes. Whatever they say about it.
Yes.
So that they subjectively will see that they can kill him.
Yes. Well, my lord, it throws the floodgates open. Any assault can be attempted murder.
Sorry, doctrine.
Yeah, any attempt can be any assault can then be an attempted murder.
It can if you.
No. Any assault, my lord.
Well, I'll stab you in the toe.
Yes, my lord.
I don't think you're going to die.
I pour boiling water on you.
I foresee you can die.
Let's look at the medical evidence, the injuries. They were not life-threatening. Nobody even suggested they were life-threatening. No doctor, not even the States, ever suggested it. If it was life-threatening, there were extensive wounds which warranted him to be hospitalized for a length of time with special care. Yes. We're talking about somebody who walked home, my lord, after this and went to the doctor the following day.
Well, like,
yes.
they stab you in the chest and I miss your heart and there's nothing wrong with you and they stitch up the skin and you're fine.
Depends on the intention of it. It depends on the
What I'm saying
intention.
is,
There was no intention.
okay.
I'm pouring with water. While he's pouring water, he's asking him questions to get information. Oh, Lord. that can never amount to intention. My Lord, if I may deal with as far as accused number 6 is concerned, his accused number 5 is concerned, his identification is also a doc identification. The problem with his identification is the one of the name. The two, Paul and Peter, give him different names. And they give him an exclusive name. Both of them says it was throughout called by different names. And then there's a documentation. Well, that must put a question mark behind his identification. And again, if I may join the argument of my learned friend for accused number 1, as far as the drugs concerned, accused the drugs. Accused 5 was convicted of that. There's no evidence what the nature of the drugs were. If he knew what type of drugs were involved, no evidence concerning that. Drugs were never found. His words, it seems to be the only grounds for his conviction. After all, we're dealing with drugs here. His words were, we are dealing with drugs here.
Correct.
My Lord, dealing...
And we know what the drugs were.
No, he didn't know. There's no evidence to know. Particularly in this case, there's no evidence. He only referred to drugs throughout. There's no evidence at all.
No, he didn't say it was X time.
No, he didn't. He said drugs. What is drugs mean? It takes various forms.
Well, we know what it is from the rest of it.
But does he know? Did he know what it was?
Well, how would he not know? How would he know? How would he not know?
No, that's the point. Well, where's the onus? The state didn't prove that he knew that this is the drugs he was charged with. The state...
They're looking for a little bag of drugs to
Yes.
go hunting 6 kilograms of cannabis.
Take that as given, Lord. But there's no evidence that he knew what the nature of the drugs were. The Lord, aspect which is raised is that your finding on the credibility of Captain Ramahala as he then was.
Yeah.
My submission is that another court may reasonably draw the conclusion why he was, as you called him, a dishonest witness. My submission is that another court might come to the conclusion that the reason was that he was trying to incriminate the accused. It's the only reason he was lying. There's no other reason for him to have been lying. The Lordship, with respect, makes the finding and it hangs in the air. If grounded, it's only one conclusion. He was lying to incriminate the accused. And particularly if I might refer to his evidence concerning the identity of the so-called warrant statement where he applied for a warrant of arrest. We conjured up this meeting where everybody gave their full names. Accused number 1 introduces all the accused to the other accused, giving their full names. And he couldn't explain where he got this information from. He said it was from an informer. He couldn't answer how the informer got to this information because he wasn't present in the room. I asked him who was present at that meeting. He gives all the accused names as being present, but he doesn't say where he got this information from because he can't say, because he was sucking it from his finger.
The problem with that theory is that there's other evidence that incriminates him.
I've dealt with it, my Lord, but as far as accused number 3 to 6 is concerned, I submit.
And he wasn't called by the state with a view to his evidence being admissible in the trial. Remember that. He was going to be, it was because of a ruling which I made that the rule is in fact wrongly framed. It has the same effect, but it's wrongly framed. That evidence became admissible on your request.
Yes, Lord.
So what I'm saying is, if he planned to come and incriminate your accused, that plan was not very well conceived.
Obviously not, my Lord.
Because he was coming to give evidence about things which wouldn't be admissible in the trial. So how would he plan that? That just sounds so remote.
Well, that's why he was such a bad witness. He didn't plan it.
Well, anyway, none of his evidence was accepted.
Yes, because he didn't have enough time to plan. That's why. That's why he was so bad in the witness box. He was sucking the evidence.
So bad because he deliberately went to accuse one. You don't think he was coming to tell lies because he wanted to cover up that he deliberately had heard accused one?
Yes. My submission is that he was covering up for his actions, if I understand you correctly.
Why does it mean it's part of a conspiracy to incriminate him?
Why lie, my lord? Now the court will
Well, I'm saying they're even stealing on the lies.
No, my lord. It's not the lies. The lies is not. One doesn't lie for no reason.
Okay.
You lie to attain a purpose, and this purpose was to. My lord, if I may deal with the sentence.
Yeah.
One aspect is that there's a clear disparity between the sentence imposed on the accused 4 and the other 3 accused.
4 and the other accused. Okay, what's that?
Accused 4 was only convicted of kidnapping and assault common.
Yeah.
He received an effective sentence of 15 years imprisonment.
Yeah.
The other accused 5 in particular had 2 additional convictions, dealing in drugs and attempted murder. He received an effective sentence of 15 years imprisonment. I submit that there's a disparity between accused 4 and the other accused.
What's wrong with his sentence as far as kidnapping goes?
My lord, there should have been a difference in sentence.
Well, the other one was convicted of dealing.
Yes.
And attempted murder. 5. We're talking about 5.
Yes.
And he got 15 years. What's wrong with 15 for dealing?
But it's not effective, my lord.
But what's wrong with it?
As objective.
I've given much harsher sentences. I gave someone, I think, 17 or 18 years for 3 or 4 kilograms of cocaine.
But still, there's a disparity between the sentences.
So we're talking that this is light. 15 is actually a gift.
For 15 for kidnapping.
Well, 15 for kidnapping for a week. Sorry, for
4 days.
4 days.
15 years ago. I submit another court may very well find that this is a harsh sentence, and there is a disparity in sentences.
Okay.
The same goes with the other accused, their convictions, their sentences. Lord, I've not dealt with all the aspects, but it's in my I'll give this nauseam previously. It's in my notice of the other points.
Lord, we're going to ask the matter stand down till tomorrow. It's been set down for the whole week. I understand that
we're not wasting time.
It's not about wasting time, if your Lordship.
Then you can't say because it's a week you can argue at your leisure.
My Lord, may I please address the court? The
Yes,
situation.
I want you to address it.
Yeah, the situation is as follows. Mr. Krejcir withdrew as the instructing attorney, as your Lordship is well aware. Accused number 2 was spirited away 2 weeks ago and kept somewhere in Venga, and only returned to Johannesburg Central Police Station on Friday evening. The first opportunity that the attorney had to consult with him was yesterday for a very brief period of time after certain instructions were made. There were certain instructions given with regard to special entries that needs to be made. Unfortunately, in order to comply with those instructions, my Lord, there needs to be a consultation with Mr. Krejcir. I understand that he's been overseas and he only returned this morning. Despite my attorney's best efforts, he's not yet had the opportunity to speak to him. And we would like to have the opportunity to discuss these instructions with him and deal with it in the proper course. A special entry needs to be made before a leave to appeal is argued, my Lord. And there needs to be certain other provisions that need to be complied with, inter alia, dealing with the aspect of condemnation. Cannot do that because of the time period that's lapsed since conviction and the special entry. and good cause needs to be shown. None of that can be dealt with, my Lord, without consulting with Mr. Greville.
If I give you an opportunity to argue the special entry after you've argued the
Lord,
leave to appeal.
I would submit, my Lord, that the question of the special entry could affect the manner in which the notice, well, the leave to appeal is argued. I understand.
To the extent that it affects it, well,
I'm
flexible. I'll help you to argue whatever you need to argue, subject to what the other counsel have to say.
Indeed.
But I think you should carry on. You've been here throughout the trial.
Yes.
You've been involved throughout the trial in great detail. You've had a record. So the issue as far as leave to appeal, you can argue in any.
Indeed.
And you have to argue at some stage.
I have to.
So if you get leave to appeal, if you get a chance to argue now, why shouldn't you argue now?
I would be prepared to continue it on the proviso, my Lord, that we would then be granted the opportunity, if needs be, to amend the application insofar as it's needed.
We can just find out what the other counsel has to say. If you have any objection to this.
Not at all agreeable.
Mr. Mashiani, the reason why the leave to appeal should be argued and then subsequent special entries can be dealt with, subject to the right of the accused if he's prejudiced by what comes out at the end to amend the leave to appeal and deal with it accordingly.
I submit there's no reason why we should not proceed. I submit, my Lord. Earlier in the morning, my learned friend indicated that she's in principle prepared or ready to argue, and then what has changed in the meantime, I cannot say. I submit it will just be a waste of time if we should postpone this matter.
So I'll give you an opportunity to argue the leave to appeal to the effect that the special entry application impacts on the leave to appeal. You'll have an opportunity to deal with it later, and you can argue whatever the confirmation is at the time it comes to argue the.
Of course, and as the court pleases, my Lord, and then also insofar as it might impact on certain submissions that could potentially be made, as the court pleases.
Let's deal with the. Right, Ms. Vandenhoeven. So, on that basis, I'm going to hear you on the leave to appeal, and my ruling is that the special entry issues can stand over, and to the extent that any of the special entry issues impact upon the leave to appeal argument, you have the right to re-argue such points.
Indeed, as the court, we indebted to the court.
Right.
Lord, the manner in which I wish to address my application to your Lordship is to first deal with the 3 counts on which accused 2 was convicted, and then I want to deal in general with certain issues that I submit with the greatest of respect this honourable court erred in. Now the first issue then, my Lord, pertains to count 1, and that is the...
You will counsel over your head.
I think
your notice of
everybody's got...
application.
I will make sure that
I've got the notice of application. Is that
yes,
the...
that's notice. We're just on the notice.
Okay, right. Okay. Does everyone have this?
We don't, my Lord. If a copy can be made available in due course.
Okay.
Thank you.
So you happy, Mr. Spanenberg, you're right?
Yes, we will do so.
Yes.
Mr. Mashiani?
I have a copy.
Right, thank you. Okay,
My
let's
Lord,
go.
argument was already addressed originally to your Lordship on the issue of the conviction in dealing in methamphetamine. Now, we still maintain the argument as we then have, my Lord. Your Lordship erred in convicting the accused.
No drugs, no ID.
Indeed, because not only, my Lord, I submit that your Lordship's finding, in that your lordship says I'm entitled to take judicial notice by looking at the Oxford Concise Dictionary online, and I can now take judicial notice of the fact that...
No, it's not even that.
It is.
What it is this. I say that if I say it's a dog, then everyone knows what a dog is. Now you say it's us, therefore everyone knows what us is. You say that's judicial notice, right?
Indeed, my lord.
Okay.
The manner in which it's done, because I submit...
Well, I understand your point.
But I'd like to embroider on that, if your lordship would bear with me. I submit, my lord, that if your lordship's finding in this regard is to stand, it would open up a floodgate in respect of convictions where the state sits back and they feel that they don't need to prove when one deals with the act, whether it's a dependence-producing drug or whatever. The case law so far has been, I submit, strict and said, if the state intends to prove that somebody dealt in a specific substance, the state needs to prove that that is indeed a substance. And this is not done. But this goes further than that, my lord. Your lordship was also not afforded the opportunity to hear any expert evidence presented by the state as to whether methamphetamine indeed has the street name in this country of tick or ice. Lordship was further not afforded the opportunity of hearing...
So you say no expert, no proof?
No expert, no proof. But it goes also one step further, my lord, because your lordship was not given... or the state didn't present any expert evidence as to street value, what the appearance is under normal circumstances, how it's distinguished from other similar substances, how it's normally packaged, how it looks like. I would almost go as far as to say how it tastes like, what the appearance is.
But these were dealers, Ms. van den Heuvel. These were dealers. These people were dealers. They know what they're talking about. When they say it's X, this is not some person on the street who says, I went and bought something and it could have been rat poison. This is the man who's selling and creating the rat poison.
But except, my lord, there's no evidence to that effect. There was no evidence presented to your lordship that accused number 2 is a dealer. It goes further than that, my lord. Your lordship would recall that both Sobaba and doctor that gave evidence at no stage referred to the particular substance. In fact, my lord, the evidence, I think, of doctor was, and I've mentioned that in my heads, that even when Morris, that's now the person that was buying it, looked at it, he says, I don't know what this is.
He's the one who said it should be wet and cold.
That's not that person. But
because it's us.
In fact, I think it was doctor that gave the evidence. He touched it and it was wet and it was ice, or Sababa.
Yeah.
Now, the person that was...
in case it melted.
Is the buyer, my lord, and that's the point. The so-called now buyer, this is Morris, the witness that was never... that the police never endeavoured to find...
Well, he's some unsophisticated person. Didn't he sell it for some insignificant amount?
Morris never gave evidence, my lord.
But there was some thought that it may have been sold for some really small money.
But that's my point. Your lordship is actually making my point, yes. And that is that nobody in this court professed to be an expert in methamphetamine, tick or ice. None of them could assist your lordship to draw the inference that your lordship has drawn at the end of the day.
Well, if I look at it and I say it's a dog, it's a dog.
But my lord, this is not a dog. This
well, what's
is
the difference?
If this is a case, let me use your lordship's example. Let's say this is a case about a bull terrier, whether it is indeed a thoroughbred bull terrier. Now your lordship can look at it and say, well, I see a dog. Somebody else can say, well, I see something that resembles a bull terrier, but it's not a thoroughbred bull terrier because it's in fact inbred with another dog.
But now I'm exporting it. I'm exporting it.
But your lordship can't jump to... Your lordship
you've got to lead all the things together.
No, but your lordship is jumping...
I say it's a dog and I'm exporting this dog and I know that I'm going to get money for this dog and I know that I have to act unlawfully to try and surreptitiously export it. Now you've got a whole lot of things which you all put together.
Not about, my lord. We're talking about a thoroughbred bull terrier, and that's the difference.
Okay.
This is not some general allegation that we're going to export a dog. I'm saying I'm going to export a thoroughbred bull terrier.
Yeah.
And that is where I submit the state has failed to come short.
Okay.
And that is where I submit.
It's back to the expert point.
Indeed. We submit, but as I said as we've submitted to your Lordship, that it's not only with regard to whether the state, through expert evidence or otherwise, proved that the substance is indeed methamphetamine. The state did not prove, and your Lordship later on in your own judgment makes findings as to the packaging, the weight, the value, etc. All of that comes back to the issue of the expert.
Yeah.
We submit thus, my Lord, that another court will come to another finding on that particular issue.
I understand your point.
My Lord, if I could just then continue with regard to the drugs. Your Lordship would recall that Lukele, when he gave evidence, at no stage, and we say this materially impact on your Lordship's finding that the content of this bag was indeed drugs. And that is that Lukele at no stage stated that when he was questioned, when he was taken away from his house, if we accept that all of that happened, nobody ever said to him, it's a bag that contains drugs. Throughout, everybody referred to money. Your brother, doctor, owes money. Your Lordship would also recall that, and this issue was also highlighted during the course of argument previously, is that when doctor made his original statement, he also did not refer to the content of this bag by name. He just talked in general terms as a doctor. He just talked in general terms about drugs. Never said that the idea was or the instructions was pertaining to a specific drug. So it's not only...
Why would they tell him?
Look, why
would they tell Lukele?
Except, my Lord, the point I'm trying to make is not whether they told him or not. And it's not Lukele, it's doctor.
No, but both of them. Why would they tell him? Why would they say, this is what you're exporting? They just say, no, we need this done.
Lukele is one issue, my Lord. My point...
We're now doctor. No,
my submission is about doctor. And that is that when doctor finally gave evidence, he absolutely contradicted what was contained in his statement, because now suddenly he came and he referred to it as a specific substance. The point about doctor then goes one step further. We submit that your Lordship failed to take into account the importance of doctor's evidence as to the exportation of some illegal substance. Because in order for your Lordship, and your Lordship in fact made findings that there was trial runs or dummy runs, and we submit that your Lordship shouldn't have made that finding, because the Lordship would recall that doctor gave, or he made one statement to the police, and in that particular statement, not only does he contradict his evidence in court as to the manner, the time, the place, and how he allegedly met accused number 2. But he suddenly now comes and he tells the court, despite the fact that he said in his statement it was the first time that he met him, accused number 2, and this was what was arranged, and that it happened 2 days later. He comes to court and he tells this honourable court that there's been 2 dummy runs. And he explains it to this honourable court in great detail. Now, we submit to your Lordship that this is not a question, as your Lordship put it, of embroidering or amplifying an original statement. This is a clear contradiction. And insofar as it is a clear contradiction, it affects his credibility. Because it affects his credibility, your Lordship cannot rely on his evidence in that regard in any form or manner.
Yep.
My Lord, I then, if your Lordship would just bear with me. Lord, I then deal with count 3, that is the attempted murder. Your Lordship would find that at page 6.
I'm there.
Now, We submit that, again, that the state didn't prove beyond a reasonable doubt that it was indeed attempted murder. And the arguments in that regard is very much along the lines as what was stated by the previous two counsel, except we go one step further. And we say that Your Lordship made a factual finding that's incorrect, in that Your Lordship refers to Dr. Nkosi as the doctor that in fact initially examined the accused, whereas not only was it Dr. Nkandla Mandla that examined him, but he was indeed the doctor that also completed the J88.
Yeah.
The issue then further is
Well,
that
assume I made that mistake. What difference does it make? What impact does it have? I called him George and he was
Peter. It's a factual
Peter.
finding that's incorrect.
Well, it's got no. The other finding was correct, assuming that I attributed it to the wrong person. Let's assume, but the fact that I found was a relevant fact, and there's no attack on that.
I'm going to go one step further, my lord.
Yeah.
Your Lordship then totally, and I say it with the greatest of respect, disregard Dr. Nkandla Manda's contemporaneous notes. Your Lordship would recall his evidence was that he is an expert, he's a medical doctor. He made contemporaneous notes at the time that he saw him.
Yes, and they're on the file.
In fact,
we got them.
And his contemporaneous notes was that he observed primary burn wounds. He explains to this honourable court in great detail what constitutes a primary burn wound, and he draws the distinction, then he goes further, draws the distinction as to how, in medical terms, as an expert, one would describe any form of wound that's either got blistering or healed blisterings. And he says that is either second or third degree burn wounds. And he says, according to his contemporaneous notes, it was undoubtedly primary burn wounds, and the manner in which it would manifest itself is by swelling and redness. Your Lordship then goes, and I submit with the greatest of respect, erroneously, and say, well, he prescribed certain medicine to him. And why would he describe medicine to him if it's not serious? The Lordship, however, failed to take into account when the state presented its evidence, it never asked the doctor as to why this medication was prescribed, what he thought of the seriousness or otherwise of the injuries that he treated, and I put injuries in inverted commas, and what exactly the reason is why he prescribed this medication.
The problem with his evidence is that objectively the person who was kidnapped had injuries, which were seen.
I beg your pardon, Lord?
The person who was kidnapped had injuries, and they were seen. And they still existed at the time that you had him examined by the skin specialist.
Except, my Lord,
who said that these are injuries, they're consistent with that, and that corroborates it.
Except, my Lord, I submit that Your Lordship could not rely on the J88 that was completed by Dr. Mia in any formal manner whatsoever. Because Your Lordship would...
That's the doctor that you wanted him to be examined by.
Because by learning...
And who came and who didn't come physically, but you accepted that his report was true and correct.
Well, that
and the accused, the kidnapped victim showed us the injuries.
No, Your Lordship, what in fact happened was, and I will, after the lunch adjournment, refer Your Lordship to the specific pages as the following. When the J88 came to court that was complete...
The first one?
The second one. The one completed by Dr. Radovan Mia. Your Lordship asked my learned friend for the state whether this is agreed and can it be handed up by agreement. My learned friend then specifically stated that only insofar as where the injuries are situated or what was observed, there was no admission at no stage, my Lord, by either the defence or the state that the content of that J88...
Well, it showed the injuries. I wasn't going to allow him to be stripped naked in court. So it was the way in which he was stripped naked in private and the report was furnished. That was the purpose of him going to Mia. You agree? That's why I went there.
Except, my lord, this is
Otherwise, he
an
had to
examination.
take off his shirt in court in front of you and others, which I said was not a proper mechanism by which people should be treated.
Except, my lord, that what was noted, if your lordship goes back to Dr. Mia's report, your lordship would note he doesn't say these are injuries that happened so long ago and that I find is consistent with it. In fact,
No, he says he's got these injuries, he's got these marks. And the witness said, I had these marks, they come from there.
Except, my lord,
So now, why don't they come from there?
I submit, my lord, that your lordship's finding in that regard is not consistent with the proven facts.
Okay.
Your lordship could not rely on what Dr. Mia noted and elevate that to evidence as if it is proof of an injury that was sustained because of boiling water being poured on the Lekele at that particular point. In fact, unfortunately, I don't have it with me, but I'm sure I can find the wording that was used by Dr. Mia in this J88, which I still submit was never elevated. It's not evidence before this court. It says very
It was the
clearly,
witness, it was a person that the witness was sent to with a view to describing injuries which he saw. And he did that, and that's how it came back.
Except, my lord, it's not...
Was there no purpose in him going there? Then he should have been stripped naked in court. That's what you wanted.
That's not what should have happened in court, my lord. I still, at that point, took issue with your lordship, which I still do, is that the injuries that was described by the witness at that point was injuries on the head, on the side, and on the one shoulder. And again, if your lordship looks at what is contained in Mia's report, it's contradictory to even what the witness stated in court or the places that he identified where he sustained the said injuries.
Okay. Well, this is the same argument you've addressed before.
My lord, the submissions then pertaining to the attempted murder is that the state in fact proved, and again we come back to the issue of presenting expert evidence, they failed to prove that the injuries that were sustained could lead to death. I.e., so that we can come back to the point where the lordship could make a finding on evidence presented by the state, evidence that your lordship can accept that these injuries could have led to death. In fact, my lord, we've submitted the last time, and we still submit to your lordship at this point, that if your lordship takes a holistic view of the evidence that were presented as to what transpired on these few days, your lordship cannot come to the finding that there was an intention to murder in any form or manner. In fact, the intention clearly establishes somebody that's being kept with one purpose and one purpose alone, and that is to try and find his brother. And that is mutually destructive of a version of a person that's been kept and assaulted with the purpose of killing this person. In fact, the ultimate result...
It doesn't have to be assaulted with the purpose of killing. It has to be assault with foreseeing that that man can die.
But even that, my lord, as I said, your lordship can only make that finding, and I've made the submission, if there's evidence from which your lordship can make a finding that this kind of injury could lead to death. And I submit...
The poor boiling kettle of water on a man's head.
Yes, I submit, my lord, to your
You think
lordship...
he's not going to die?
No, I submit your lordship cannot take judicial notice of that, and the state needed to prove that.
Okay, well, I
by
understand your
presenting
submission.
evidence.
It's the same point.
My lord, we further submit to your lordship that the clinical findings of Dr. Nkandla Mandla totally contradicts the evidence of both Lekele and Peter and Paul with regard to the injuries, and that your lordship neither mentioned it nor failed to take into account that there is a clear contradiction in that regard, and that your lordship therefore cannot accept the evidence presented by these persons in respect of the injuries. In fact, your lordship would also recall that when Peter, Paul and Lekele were confronted with their statements, it was quite clear from the statements that they not even at the time when they made the witness statement described anything that could remotely assist this court in saying, well, at the time they actually saw the same injuries they're giving evidence about. My Lord, we then come to count 2, and that is the issue with regard to the kidnapping, and that starts on page 8. I submit that Your Lordship, despite the fact that Your Lordship at no stage took into account, let me start in this manner, that accused number 2 was never identified by Lukele as being one of the kidnappers. The only person that puts accused number 2 on the scene during this process or identifies him as being there is in fact Peter and Paul. Now, if I can go back, my Lord, to the issue of the acceptance of Lukele's evidence with regard to the kidnapping, I submit to Your Lordship that Your Lordship failed to take into account that Lukele made 3 different statements. In each of these statements, he describes the kidnapping differently. He describes what transpired during the kidnapping, and I'm now referring to the very first kidnapping. He describes that differently. He deals with the issue as to whether he can identify the kidnappers or not in a different manner. The same pertains to what the vehicles that were noticed at the scene. I then say that, or we then submit, my Lord, that he then, both himself and Doctor then described to the court a set of events that unfold. It's the issue of the phone calls that were made to Doctor, when it happened and how it happened. And there's no...
Just go back, just to say that again.
Your Lordship would recall the evidence was that at the time that he was kidnapped, once he was transported away from the house, he was forced to make a phone call
Yes.
to which there was no corroboration presented in that respect whatsoever. Doctor, in fact, doesn't make any mention of such a phone call when he gives evidence. It then continues, my Lord, we know about a second set of events where there was allegedly a phone calls made, and the evidence that was presented to Your Lordship in the form of Peter's Vimavoka evidence is that there was some more phone calls made, and these phone calls were made at a very specific place.
These were the ones made on the highway.
That's the ones at London exit on the highway.
Yeah.
We submit, my Lord, despite the fact, well, Your Lordship should have taken into account that the state or the police had the opportunity to present Your Lordship with objective evidence to corroborate that, i.e., in the form of the cellular data of both Doctor and Lukele, and Your Lordship would have had no doubt as to the veracity of this whole version preferred by the state. Yet, despite Captain Ramohala being cross-examined about this and being asked why he never did it, he could at no stage explain to the court why he didn't go to the trouble, despite having gone, Your Lordship know, and obtaining 58,000 pages of cellular data in respect of the accused. He does not go and endeavour to obtain corroboration aliundai of this very important aspect. We submit, my Lord, that Your Lordship should have taken into account that not only did Lukele, with regard to his evidence as to what transpired, contradict his statements, or 3 statements in material aspects, but it's also contradicted by the evidence of both Peter and Paul. And the one issue that we submit is of the utmost importance, my Lord, is the issue pertaining to where Lukele was allegedly kept, awaiting on his version 3 days later a trip to Ermelo. In his statement, he throughout stated, and the first time he changed that version was when he gave evidence, that he was kept at the office. Now we submit, my Lord, that is a very important point, because it goes to the heart of whether his evidence is acceptable. Because his evidence only changes once he comes to court. And when he's confronted with this change of evidence, he says that he's informed my learned friend for the state that this is not correct. And yet my learned friend for the state at no stage disclosed to this court that, listen, there was a deviation of his evidence. Alternatively, what I submit should have happened was that my learned friend should have taken a statement dealing with this aspect as it manifests itself in a material contradiction. This then, my Lord, goes further, and we submit that your Lordship should have taken into account the fact, despite the fact that there's constant reference to an alleged safe house, the state did not come at any point and present your Lordship with any evidence aliundo or objective evidence from which your Lordship can make such a finding. There was evidence given, but it was at no stage corroborated that the police apparently went to a place that was identified as a safe house and took photographs. Yet none of those photographs were ever disclosed to the defence. And insofar as it was never disclosed, I submit your Lordship should have drawn a negative inference from that. Alternatively, your Lordship should have made a finding that the evidence that the Kelly was allegedly kept at a safe house is open to doubt. My Lord, I then continue to deal with general submissions with regard or in respect of the manner in which your Lordship dealt with the evidence that was presented. We respectfully submit that your Lordship failed to properly evaluate the state's case, and in particular all the contradictions that's contained in the state's case. A reading of your Lordship's judgment is to the effect that your Lordship basically took into account what your Lordship thought was important to make findings on, and your Lordship excluded all what we submit is the difficult aspects in the state's case. And that, we submit to your Lordship, is an incorrect way of evaluating the evidence and making findings in respect thereof. We further submit, my Lord, that your Lordship did not properly deal, when one then takes the version of accused number 2 with his evidence, and particularly with his evidence with regard to the role of Colonel Kimba, the role of Pumi Piri and the other people, and the particular lies of Captain Miramohala. Your Lordship at no stage, when your Lordship evaluates, and I submit that your Lordship did that very cursorily, the evidence of accused number 2, your Lordship doesn't even mention his evidence in that regard. What is also important, my Lord, is that your Lordship was aware from the start that the state on their version obtained some 58,000 pages of cellular data. Your Lordship then made an order that the state should disclose what number of pages and which pages the state intends to use in this matter. And at your instance,
because you couldn't deal. You couldn't deal with all the pages.
Indeed, my Lord. The state then placed on record.
And you agreed that that was a proper course. You wanted it done that way. Yeah.
If I may continue, my Lord, because the issue is not that. The issue is that the state at that point stated for the record that they intend to use the cellular data that they've now limited, the 100 pages, in the course of their case. Yet, at no stage, when accused number 2 gave evidence, and he said, I wasn't there, my cellular data would prove that I wasn't there.
What is that? I don't understand the logic of that.
The logic
You can't go from the phone to what happened. You can go from what happened to say it's corroborated by the phone.
And the converse of that. If
and
you
you're dealing with someone here who has full knowledge of the fact of the ability to track whereabouts by use of phoning, all these sorts of things are known to him. The problem of using a phone is known to all of the accused.
But there's no such evidence, my Lord.
Well,
your Lordship is again jumping to a conclusion.
Remember when they went to London Road Like, you mustn't use the phone because this can track you, people can find you, all these things. These people are aware of this.
But
So you can't just say because the phone record says X, therefore X is the answer.
No, but your lordship, with the greatest of
You should have used it if you wanted to.
No, but why should we use it? We don't bear the onus, my lord.
So they're at risk. That's all. They're at risk.
No, the point is...
That's the point. They're at risk, not you.
If your lordship would allow me just to finalize...
I'm allowing you, but you're not dealing with it.
No, I am dealing it with my lord. If I come to court and I say to your lordship, I give evidence under oath, the state is in possession of my cellular data. I say, on this day at this time, I was not at this place that you said I was.
Right.
And the state is in possession of the cellular data, and they can contradict it with the cellular data. Why don't they do it?
Well, they may not be able to. We don't know.
But the point...
Why does the cellular data, the phone could have been in the possession of his wife, as in fact in one set of circumstances it came out the phone was not in his possession, it was in someone else's possession.
But it was never...
No, all I'm saying is this. You can't go from saying a phone call made at X time at Y place means the accused was there. That's all.
Except, my lord, the accused says to this court, at this point I did this, at that point I did that. And he says, this is not a question of just denying something. This is a point of saying, well, my cellular data will confirm it. And yet the state doesn't do anything to put it to the accused or take the cellular data and contradict the version of the accused. And insofar as they don't do that, our submission is that your lordship should then accept the evidence that was presented.
Well, that's where we differ.
My lord, the submission is then, and my learned friend for accused numbers 3 and further made the submission with regard to the fact that your lordship at no stage took Captain Ramohala's evidence and your lordship's credibility findings and pulled it through to his conduct in this particular case. Now, we submit with the greatest of respect, my lord.
Why should I?
Because, my lord, his evidence clearly indicates to your lordship that this is a man that had no scruples in manipulating evidence to suit his own case. It goes further than...
Well, what evidence do you say manipulated?
My lord, let's deal with his investigating diary. In his investigating diary, he talks about photographs, videos, and other stuff.
Well, where did he manipulate any of that?
My lord, by not disclosing it, we say, you said in your diary that you're supposed to do the following and you've done it.
Well, let's just look at it this way. I'm sorry to interrupt you, but really this is the same issue we've had all along. He comes along months after the event and he does things. They've got nothing to do with what happened at the event.
But
he's completely irrelevant to the event.
Except, my lord, if he then goes and he gets the CCTV footage and he looks at the CCTV footage and he says, oh dear me, it's not accused 1, 2, and 3 on it, but totally different people.
But he didn't do that.
But who says he didn't do it, my lord?
Who says he did?
We say, my lord, the fact that he lies to this court about it.
No. Anyway, you've argued all of these things before.
But we say that your lordship should have taken it.
I thought about them, and you know my answer. And I remain there.
Yes, but we submit, my lord, that another court can deal with this issue in a different manner.
Yeah.
My lord, it's 5-2. May we adjourn at this point, please?
Yeah, right. So the accused can go down. Can you try and sort out the other issue in the interim? Can you try and sort out the other issue in the interim? Ms. van den Heever, can you try and sort out the other issue?
Yes, during the lunch adjournment, we will endeavour to do so, my lord.